in on this episode of Law Weekly, more from the 50th anniversary of the Federal High Court. We hear from the Chief Justice of Nigeria and the Chief Judge of the Court. We also bring you the highlights from the launch of the book containing the valedictory speeches of the Justices of the Supreme Court, the first of its kind, and some suggestions made by senior legal practitioners to reposition the court for the future. From there, we joined the Lagos branch of the Nigerian Bar Association as it celebrated the International Human Rights Day, plus our recap of the top trending legal stories in the news. Hello and welcome to the program. I'm Shola Shoyeli. Let's commence proceedings with some of the activities marking the 50th anniversary celebration of the Federal High Court in Abuja. The event attracted justices of the Supreme Court led by the Chief Justice of Nigeria, Justice Olukayode Ariwoola, justices of other courts, as well as the justices of the host court. Also present here are representatives of the executives, lawmakers, lawyers, judicial staff workers, and other well-wishers. In its charge to the judges, the CJN warns them to take their appointments seriously. It also tasked them to be thorough in their rulings and judgments.
I implore you all to please continue to work very hard. Work hard and harder and go extra mile each time. Do not assume that what then are the gentlemen at the appellate court doing. No, let that court affirm your decision. Always write your judgment that the appellate courts will have no choice than to affirm your decision. Don't leave any loophole. To be a judge is certainly not a child's play, particularly at your court, where you don't sit on panel, you sit as a lone ranger. You sit all alone. You are the Lord of the court. Please always go extra mile. Even a simple, what you consider a simple application. It is your court. You are not there to impress anyone at all. If you need to take a break to consult your notes, to consult your books, before you rule, no application by counsel is simple. Make relevant consultations and come to give your ruling. Yes, there's no threatening. It always amazes me when counsel says, "My Lord, we shall go on appeal." Is that a threat? Is your entitlement? Go on appeal. That's what the appeal court is there for. I am glad to be here again to celebrate with you.
In another event to mark the anniversary, the Chief Judge of the Federal High Court, Justice John Soho, gives a breakdown of the cases pending in the court's docket and carried over from past years till date.
It is not in doubt that the judiciary is on trial. It therefore behoves all of us as critical stakeholders in this institution to rise up and ensure that we uphold the independence and sacredness of the judiciary, which is the hallowed temple of justice.
Established in 1973 in a single courtroom and 5 judges in Lagos, the court now has 37 divisions and 95 judges. Away from the Federal High Court to the Supreme Court, some legal practitioners have again restated the need to redefine the jurisdiction of the Supreme Court of Nigeria. There was also a call for the establishment of a Supreme Court in each of the 36 states of the country to align with the principles of federalism, as well as the need to listen more to the suggestions and recommendations of justices, especially as canvassed in their valedictory speeches. All of this and more came to the fore at the public presentation of the book, The Supreme Court of Nigeria, History, Establishment, Jurists and Speeches, written by the Attorney General of Lagos, Senior Advocate of Nigeria, Lawal Pedro, and his co-author Abdulrasheed Ibrahim. We have more from that event in this next report. It's a roll call of distinguished personalities from the bench, the bar, the executive, legislature, traditional rulers, and many others at the launch of the book and public lecture on the Supreme Court of Nigeria. The apex court and happenings there is of interest to almost everyone. And apart from the judgments and rulings, the age-long tradition of holding valedictory services in honor of retiring justices of the court provides an opportunity to learn and hear from them their suggestions and recommendations on how to make the justice system and the courts better. But did you know that there was no single compilation of all the great valedictory speeches? That's the gap that the authors have chosen to address with the book, The Supreme Court of Nigeria, History, Establishment, Jurists, and Speeches.
This idea came about when I was planning to write a valedictory speech on an occasion in which I was the most senior advocate of Nigeria at an event. And I was looking for, lawyers, cut and paste. It was a short notice, and I was looking for quick fix. Let me ask my brother, let me get me 2-3 valedictory speeches of retired justices. So I will pick from them and form. Surprisingly, I even commando my junior, Abdulrasheed Ibrahim. You are in Abuja, go to Supreme Court, they are wasting my time. Just go and meet the CR. I need valedictory speeches of our judges, of the justices that retired of recent. And he came back with 0. How can we not have a compendium of valedictory speeches of these are noble jurists? No, it's not good enough. If you can't keep record, there's some record we should keep. So we have to start with that an idea. So this publication presents the roll call of the Supreme Court from inception till date. The publication undertakes to give an insight into the composition and the establishment of the Supreme Court of Nigeria, and more importantly, the life and times of members of this prestigious apex court of our country. Since inception of the Supreme Court in this country, many of our great jurists have passed through this institution, many of whom, though not alive now, but still speak to us till date through their brilliant and remarkable judgment left behind, which can be easily assessed by any practitioners of the law, whether at the bar, on the bench, or in the academia. Replete in our law report. But the same cannot be said of their valedictory speeches delivered on their exit from the Supreme Court. This is the vacuum that this book has come to fill. With vigorous efforts and research embarked upon by myself and my learned friend Abdulrasheed, we were able to bring together 48 valedictory speeches of our retired justices of the Supreme Court of Nigeria, including those who are dead or alive. The valedictory speeches may be seen by some as not being important as judgment delivered by the justices while on the bench. But the valedictory speeches are not without their own advantages because they give room to learn a lot from the experiences and judicial careers of the retired justices who reach the apex courts. The justices often relate how they got to the judicial bench, what they met, and what they left behind. In their valedictory speeches, they often make various observations, suggestions, recommendations on how to make our justice system better. But what do we see? What do we find? After the valedictory session, that happens to be the end of the affair.
The chairman of the event, Senior Advocate of Nigeria, Wole Olanipekun, goes down memory lane. He says he's particularly pleased that the literature concerning the Supreme Court is getting enriched, but he wants the membership of the court to also get richer.
Now, about species, we have also species and species. I wouldn't know whether the speech of Nwaifo is here, whether the speech of Oguntade is there, Right, I've listened to so many of their speeches. When Wifon was leaving the Supreme Court, his speech was as controversial, quote unquote, unquote, as that on Datijo. But we are getting to a situation today, the same thing with Lagos. Ejambi Eko, we call him Lagos. Yeah, Eko. Now we are getting to a situation whereby judges of the Supreme Court, when they are retiring, they're already bottled up. And they want something to detonate, whether the emotion, and they seize the opportunity to air their views. To me, also, it's healthy. Although one should not throw away the baby with the bathwater. Caution. But at the same time, we need to hear more from them.
The guest lecturer at the book launch, Senior Advocate of Nigeria, Dr. KY Pinero, had several recommendations for the Supreme Court of the future.
We need to examine the true concept of federalism. It's about time states start having Supreme Courts. If we are really serious about federalism, there's no reason why the states cannot have their Supreme Courts. There are certain cases that should not end up in the Supreme Court of the Federation. And I gave several examples. One of which is, for instance, why would matrimonial causes end up in the Supreme Court? It doesn't make sense. So states must have their own Supreme Courts. I also examined the mandatory retirement age of justices of the Supreme Court. I gave examples of what is obtainable, and I also quoted from the book of the learned author of the Reflections of Okuta, JSC, of blessed memory, where he also opined that Supreme Court judges must retire only by death or ill health. I was forceful in my arguments that we need to consider this.
The Chief Judge of Lagos agrees that not all cases need to get to the Supreme Court. He also used the opportunity to advise his brother justices to prioritize their health and retire when tired.
When it comes to retiring until death do you and service part, I don't agree. You must assess yourself. When this increment of the retirement age to 70 years came, I had the opportunity of speaking with some of my colleagues, and I said, look, whether 70 or 90, you will know when you are tired. So when you are tired, don't wait. Go home and rest. Because there is nothing you want to do again which you could not have done if you were actually interested in the work and for posterity that you would not have done before you got to the stage when you became tired. If you are no longer in good health, please retire. And nowadays, although the retirement benefits might be peanuts, but I don't think any judge who had worked for quite some time or who had been in practice for quite some time before coming to the bench would be a poor man. No. Ostentation apart, but to live a simple, quiet, and reasonably comfortable life, any judge who has spent 10, 15 years on the bench should be able to do that. So why do you want to kill yourself on the job?
The Lagos state government, on its part, asked everyone to commit to partnering with the judiciary to guarantee a system that all citizens trust and respect.
The Supreme Court must remain steadfast in its commitment to dispense justice while embracing advancements in technology, evolving societal norms, and the ever-expanding frontiers of the law. I call upon all stakeholders, legal luminaries here present, scholars, practitioners, and citizens alike to join hands in ensuring that the Supreme Court continues to be a beacon of justice, guided by wisdom, impartiality, and unwavering dedication to upholding the rule of law. Let us reaffirm our commitment to fostering a judicial system that commands the trust and confidence of every citizen.
Then followed the citation of the authors and the book review and the launch.
I unveil this book to the glory of God and the benefit of mankind.
Chief Ibrahim, legal practitioner, Judge Republic, Supreme Court of Nigeria.
The book has 522 pages with a foreword written by the Chief Justice of Nigeria, Justice Olukayode Ariwoola, who amongst other things recommended it as a useful tool for lawyers, judges, students and indeed everyone interested in learning more about the workings of the Supreme Court. On Monday, the 11th of December, the Lagos branch of the Nigerian Bar Association joined the rest of the world to commemorate the 75th anniversary of the adoption of the Universal Declaration of Human Rights with a one-day International Human Rights Day conference, which had the theme, Dignity, Freedom and Justice for All. We have some of the highlights from that conference up next.
This conference is an initiative of the Human Rights Committee of the NBA Lagos branch. It attracted judges, lawyers, members of the academia, students, lawmakers, representatives of the diplomatic corps, representatives of security agencies, traditional rulers, and many others. The chairman of the branch, Bisima Konjuola, who set the tone for the event, notes that upholding human rights is essential in any civil society. He also speaks about some of the initiatives of the branch in upholding human rights.
Aligned with our core objective of promoting the rule of law and respecting human rights, we consistently organize symposia such as this, and we collaborate with authorities to ensure the recognition and protection of citizens' rights, irrespective of the social, economic status that they may belong to. And if at any point in time you see or you know anybody whose rights is being infringed upon, kindly call on the Human Rights Desk of the NBA Lagos and we'll be quick to get into action.
The vice chairman of the branch doubles as the chairman of the branch's Human Rights Committee. She speaks about some of the practical results the committee has achieved so far, as well as other action plans.
The committee has achieved a lot, including securing a conviction in the murder charge of the State of Lagos against Inspector Drambi Vandi, embarking on courtesy visitations to the offices of the different law enforcement and security agencies in Lagos State, securing their collaborative efforts in further ensuring the entrenchment of the rule of law and effective administration of criminal justice in Lagos State. The committee has indeed taken up a number of pro bono cases, with so many more believed to be out there requiring our legal service. From January 2024, the Human Rights Committee of the NBA Lagos branch plans to move on to the next phase of its pro bono activities, such as correctional centers and police station visitations, with a view to helping to decongest these places.
One of the guest speakers, a professor of international law and former dean of the Faculty of Law of the Obafemi Awolowo University, notes that the theme of the conference, Dignity, Freedom and Justice for All, is only achievable when all institutions and persons are involved and are accountable for the exercise of such powers.
Crucial areas that I've mentioned is public interest litigation, particularly in the context of our team for this year. And you know, it's something that is already well developed in India. Now, where they form what they call People Union or Civil Liberties Union. Now, those ones are to take up people's cases where they are too poor to actually initiate action in courts on their own without being met with the objection that they have no locus standard. I think it's something that we need to work hard on very much here in Nigeria.
Other speakers also threw up some of the challenges and solutions militating against the protection of fundamental human rights in the country.
The judicial system is designed for specific purpose. The intention of the judiciary is not to deliver justice. It is to pretend that we are a law-based society, but because of the need to preserve the advantages of the sovereign, we get judgment instead of justice.
And anything that is wrong with the courts today, we are part of it. We're in this room. We are the cause of it. Because there is no judge. There is no magistrate. There is no customary court precedent that is not a lawyer.
We need to show our own example. Whatever you are given, the assignment you are given, do your own and make a mark. History will record you as having contributed. We need to also look inwards. When we are talking about human rights generally, for us to fight for the masses, we need to do what Rotimi Amaechi told us in Port Harcourt, 2014 or thereabout. Physician, heal thyself.
The Human Rights Committee of the NBA Lagos branch also used the opportunity of the conference to reiterate its commitment to partner with like-minded individuals and organizations to provide free legal services to indigent members of the society who are denied their rights and freedom.
And just before we go, a quick recap of some of the top legal stories in the news.
We begin at the Supreme Court, which has upheld the federal government's appeal challenging the verdict of the appellate court that dismissed the remaining charges on Nnamdi Kanu. The court insists he must face his trial at the Federal High Court. In a judgment delivered by Justice Emmanuel Agim but prepared by Justice Garba Lawal, the Supreme Court held that the Court of Appeal was wrong to hold that Kanu could not be tried again based on the illegality perpetrated against him by the federal government following the invasion of his home. The Apex Court subsequently allowed the appeal of the federal government and dismissed the cross-appeal filed by Kanu. From the Supreme Court, we move to Rivers State, where the State High Court has restrained Martin Zamewole and Dumle Mao from interfering with the activities of Edison Ehie in his capacity as Speaker of the Rivers State House of Assembly. The ex-parte order, which was issued by Honorable Justice Monina Danagogo in Port Harcourt, the Rivers State capital, warned against the use of thugs and police officers to forcefully gain access into the premises of the House of Assembly. The judge further restrained the defendants and their agents from disrupting and interfering with the exercise of their duties. From Rivers State to the FCT High Court in Abuja, where Justice Keziah Ogbonnaya declined a request to recuse herself from a libel suit filed by a former Foreign Affairs Minister, Mr. Jeffrey Onyama. Mr. Onyama had sued the career ambassador in the Ministry of Foreign Affairs, Lilian Ono, for libel, alleging that she defamed him in a series of memos she sent to him while he was the minister. But Mrs. Ono alleged bias against the judge, urging her to stop adjudicating on the suit. Mrs. Ono also petitioned the National Judicial Council, asking it to discipline Justice Ogbonnaya for being overtly partial in her handling of the suit. Her grounds is that she hails from Enugu State, where Mr. Onyama comes from. And we round off at the Federal High Court sitting in Jos Plateau State, which sentenced the Lebanese national to 29 months imprisonment for charges bordering on abuse of at least 5 minors' position of vulnerability and sexual exploitation. Justice Dorcas Agishi found the accused, Jabir Iskandar Sleman, guilty of the 16-count charge preferred against him by the National Agency for the Prohibition of Trafficking in Persons, NAPTIP, and convicted him accordingly. The 61-year-old Lebanese residing within the Jos South local government area was charged with willfully employing and abusing the vulnerability of 5 minors as well as sexually exploiting them. These offences are contrary to the provisions of the Prohibition Enforcement and Administration Act of 2015. The trial extended over nearly a year, during which the accused was found guilty on all 16 counts. Subsequently, he received a 12-month sentence for counts 1 to 8 and a 17-month sentence for counts 9 to 16, with no option of a fine.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Sheyele. Thank you for watching and see you next week.